What's up, everybody? So we got a copy of the state's response to Kathleen Zellner's latest motion on behalf of Steven Avery in an attempt to get him an evidentiary hearing. First off, huge thanks to Twitter user at MJEEBS for getting us a copy of the state's response. I will link his Twitter and his YouTube channel in the description below. So make sure to give him a follow and subscribe to his YouTube channel as well. So it starts off with stating, response opposing a motion for an evidentiary hearing and post-conviction relief. Now, I cannot say that I'm surprised at all by the state's response. We knew that was coming. Now, this does not mean he isn't going to get one. This is just the state's response. It states, the state of Wisconsin, by undersigned counsel, opposes defendant Steven A. Avery's motion for post-conviction relief and request for an evidentiary hearing. He claims that his newly discovered witnesses Thomas Sawinski's testimony would have allowed him to meet the three-part Denny test to include third-party evidence at trial and allege that Bobby Dassey, Avery's nephew, committed the murder and then planted all of the evidence to frame Steven Avery. He also claimed the state committed a violation of Brady by failing to turn over defense counsel a snippet of audio recorded by the Manitowoc County Sheriff's Office when Thomas Sawinski called them on November 6, 2005, which Steven Avery claims would have led defense counsel to Thomas Sawinski and allowed them to present this theory of defense instead of the one they chose. He also attempts to relitigate his Brady claim regarding Kevin Lowe's assertion that he told Sergeant Andrew Colburn on November 4th that he saw a car that looked like the victim's parked on the side of the road. Finally, he asks this court to order a new trial in the interest of justice. The motion is insufficiently pled, unsupported by sufficient facts, and the record conclusively demonstrates that Avery is due no relief to either of his newly discovered evidence or his Brady claims. And circuit courts have no authority to order a new trial in the interest of justice, unless the request is raised on direct appeal. Accordingly, no evidentiary hearing is necessary, and this court should deny the motion. And then it goes into a background on what happened. Teresa Halbach, a 25-year-old photographer, disappeared on October 31st, 2005. She was last seen walking towards Steven Avery's trailer after photographing a van on the salvage yard per Avery's request. She was reported missing on November 3rd, and her RAV4 was found on the Avery property on November 5th. Police searched the Avery property many times. It doesn't state that, but they did. They searched his bedroom like 7 or 8 times, searched the Avery property, and found bone fragments from nearly every bone in the human skeleton in Avery's burn pit, with DNA matching Teresa Halbach's, and 2 skull fragments with bullet holes in them, along with rivets from a type of jeans she owned. Avery and the victim's blood in the RAV4, the burned remnants of Teresa Halbach's camera and other items, Mrs. Halbach's RAV4 key, which was found in Steven Avery's bedroom with Steven Avery's DNA on it. We all know of how that key magically showed up on the 7th or 8th search attempt in Steven Avery's bedroom. Avery's DNA on the hood latch of the RAV4, and shell casings and bullet fragments in Avery's garage that were fired from the gun in Steven Avery's bedroom, and one of which had Teresa Halbach's DNA on it. A 5-week trial commenced where the state's theory was that Avery shot Teresa Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and the camera and cremated Teresa Halbach's remains, transferred some of them to a burn barrel, and hid the RAV4 until he could crush it in the Avery car crusher. Avery's theory of defense was that the police were biased against him because of a wrongful conviction lawsuit he had pending against Manitowoc County and the Sheriff's Department, and planted the evidence against him. That's a very good theory. He was owed $36 million. And I'm going to assume that Manitowoc County and that area does not have the $36 million to pay Stephen Avery, allegedly. The jury found Avery guilty of first-degree intentional homicide and felony possession of a firearm. He was sentenced to life without the possibility of extended supervision. Avery appealed and the conviction was affirmed. The motion was denied and the subsequent appeal was stayed and later dismissed on Avery's motion. Avery then, between 2017 and 2019, filed an additional 6 post-conviction motions alleging claims of error, all of which were denied. Avery appealed and the Court of Appeals affirmed. Supreme Court denied his petition for review on September 17th, 2021. Avery then filed the motion at issue here seeking an evidentiary hearing. He claims that the state committed a Brady violation by failing to provide his defense counsel with a snippet of audio recorded by the Manitowoc County Sheriff's Office on November 6, 2005, which they did. When Thomas Sawinski, who used to deliver newspapers on the Avery property, called to report that he needed to speak to someone about the investigation into Teresa Halbach's disappearance. He also alleges that Sawinski claims he saw Bobby Dassey and an unidentified older male pushing a dark blue RAV4 down the road sometime after Teresa Halbach's disappearance, which Avery alleged is newly discovered evidence warranting a new trial because it would allow him to set forth a third-party perpetrator defense. Finally, he additionally seeks a new trial in the interest of justice. Argument: a circuit court may deny a post-conviction motion without a hearing if the facts alleged do not entitle to relief, or if one or more key factual allegations in the motion are conclusionary. To sufficiently plead a post-conviction motion, the defendant must present within the 4 corners of the document the who, what, where, when, why, and how. That would entitle him to the relief he seeks. Mere speculation presented as fact is insufficient to meet this standard. A sufficiently pled motion, however, is not enough to require a hearing. The Wisconsin Supreme Court has recently uncensored that an evidentiary hearing is not mandatory if the record as a whole conclusively demonstrates that the defendant is not entitled to relief, even if the motion alleges sufficient non-conclusionary facts. Alright, so this is going to get a bit long. I'm going to break these up into different parts, so in case you don't have the time to sit here and listen to a 30-minute or an hour-long video, however long this ends up being, I'm only into page 6 of this motion. So I'll be back with part 2 of the state's response to opposing a motion for post-conviction relief on behalf of Stephen Avery. Let me know what you think. Let me know what you think of part 1. And if you're seeing this, part 2 is uploading right now, so it will be there as soon as you're done with this one. Let me know what you think. Leave some comments below. I hope you're having a good day, and I'll see you again real soon.